Directors meeting for today, November 20th, 2012. Let's see. Present are Commissioners Palacios, Precinct 2, Palacios, Precinct 4, Flores, Precinct 3, and myself. We have a quorum. Thank you, sir. And anybody sign up?
No, sir.
For open forum? All right. Go ahead and proceed to the next item then.
Next item is the approval of the consent agenda. It's been signed off by Ms. Norma Garcia. I'll present for the board for their consideration.
So moved.
Second.
No, but this is drainage.
Yeah, that's right.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you very much, Judge Commissioners. Item 4, recognition of the efforts of the Drainage Advisory Board on the $184 million bond issuance. We have a resolution we'd like to present for this board's consideration in expressing our thankfulness to the members of the advisory committee, and at the same time extending the support to this board of directors in assisting us in moving this bond referendum forward. I believe Jaime from the judge. I'm sorry, Karen.
Morning, Judge, Commissioners. Yes, we would like to take this opportunity to thank the people that were instrumental in helping this pass, the $184 million bond issue. First of all, to the taxpayers. I would like to recognize a couple of people in the audience who are here with us today who were part of this effort to pass this resolution. I'd like to recognize Mr. Commissioner Jim Darling. You can please come up and join me. And of course, Mr. Brian Godinez, who was helping the Drainage District and coordinating all of the efforts throughout this whole campaign. And the resolution reads, Resolution in honor of the Hidalgo County Drainage District Advisory Committee. Whereas the Hidalgo County Drainage Advisory Committee, consisting of 25 appointed members from throughout the county, have worked diligently with the Hidalgo County Drainage District Number 1 and the Drainage District Advisory Board within the last year to carefully study, evaluate, and propose the best solution to enhance the county's main drainage system. And whereas a 25-member Drainage Advisory Committee was created and appointed by the Board of Directors to serve as an advisory group to the Board. The Board and the Committee served as a link between stakeholders and constituents of Hidalgo County and the Board related to the possible development, planning, financing, and implementation of the Drainage District's Capital Improvement Plan. And whereas the Advisory Committee, upon reviewing the current drainage infrastructure, agreed it was in the county's best interest to upgrade and make improvements to the drainage system. And whereas on November 6, 2012, 75% of Hidalgo County voters in the district approved a drainage bond referendum in favor of the Drainage Board of Directors issuing $84 million in bonds and leveraging a $100 million federal grant to fund 25 specific projects in the county. And whereas these monies will go towards the improvement of the county's drainage system, these improvements will also help protect and ensure the safety of our communities, including over $35 billion in property assets. And whereas through great community outreach and dedication to this project, the 25-member Drainage Advisory Committee was able to educate and inform Hidalgo County residents about the need for drainage infrastructure improvements. Hidalgo County will finally receive the much-needed upgrades to its drainage system. Now, therefore, be it resolved that the Hidalgo County Commissioners Court hereby recognize and honors the Hidalgo County Drainage District Advisory Committee for their outstanding service, dedication, and commitment to Hidalgo County. Dated this 20th day of November 2012.
Second.
All right. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And if I may, Judge, I would like to read the names of the members on the committee so they can be recognized. We had the judges' appointees were City Commissioner Jim Darling, Joe Phillips, Ann Cass, Dora Brown, and Dr. Frank Guajardo, who co-chaired the committee with Commissioner Jim Darling. Precinct 1 appointees included Mayor Hector Elizondo, David Suarez, Rene Salinas, Mayor David Simmons, Erasmo Lopez, and we had Mario Garcia and Ken Jones for technical support from the LRGVDC. Precinct 2 appointees included Joe Vera, Virginia Townsend, Carlos Peña, and Mayor Richard Cortez. Precinct 3 appointees included Mayor Marcos Ochoa, Mayor Jorge Garcia, Mayor Norberto Beto Salinas, Mayor Ramiro Rodriguez, Mayor Salvador Vela. And the Precinct 4 appointees included Ken DeJarnette, Sam de la Garza, Ernie Williams, Rene Barrera, and Richard Lefebvre. And of course, the Drainage District Board of Directors, the Honorable County Judge Ramon Garcia, County Commissioner Joel Quintanilla, County Commissioner Hector Tito Palacios, County Commissioner Joe M. Flores, and County Commissioner Joseph Palacios. So thank you very much. We are really appreciative of all the efforts of everyone involved. I know it took a lot of time, Judge, and Commissioners, to schedule all those drainage town hall meetings, but we were able to get out there into the community and educate and inform the voters. So thank you very much.
We also should include Mr. Godfrey Garza, who went above and beyond his employment as director. I mean, he attended
every
town hall meeting. He was there along with obviously Mr. Darling, who I appreciated him showing up when he did and answering all the hard questions.
Absolutely, and I'll open it up if they would have any words to say.
I do want to just state on behalf of the County Commissioners Court and the residents of the county, or as Vice President Joe Biden would say, for Hidalgo County, this is a big deal. I mean, a $184 million bond issue that the community acted on and supported it, 75% to 25, 3 to 1. That's a very impressive voter turnout and voter support, resident support, and it was possible because of the work and effort that was begun by the Citizens Advisory Committee and what occurred after that to educate the public. In that regard, I do sincerely want to thank you.
Thank you, Judge. And on behalf of the committee, we want to thank you and the Commissioners Court for giving us the privilege to serve on this committee. I might point out, too, I won my election by 52 votes, so it sure was nice to be on a 75% winning deal. The other thing is, I also got to experience the owls showing up at all the town meetings and asking questions, which you do at all your meetings, so that was kind of an interesting process. But we thank you, and hopefully these projects will be constructed relatively soon for the benefit of all our citizens, and I think will show much needed improvements to our drainage system. So we thank you for allowing us to serve.
Thank you, sir. And any comments from anyone? I'm good. If not, we need a picture.
Yes, absolutely.
Oh, Commissioner Palacios, Tito has a comment.
Go ahead.
You weren't here yesterday, so we voted on everything goes to precinct 3.
I know. Now, again, as the judge pointed out, I appreciate what you guys have done, the whole committee, not one person, but the whole committee. And I'm looking forward to the improvements that will be happening soon. Godfrey, how soon can we expect to see some movement in this?
Commissioner, as requested by the board, excuse me, we're about to be presenting a timeline to this board within the next week or two. The commissioners have started giving me the layout of their projects and the costs associated. So I am hoping that we begin the administrative process within the next 3 to 4 weeks and break ground probably by March 3rd or 4th, which is when the monies would be made available. But over the next 60 days or 90 days, we can go through the advertisement. There are projects that the plans are completed. You have some in your areas. Commissioner Joseph Palacios has some in his. I know Commissioner Flores has given us direction on his area. So we'll be breaking ground and trying to stay within those 18 months that we had committed to the citizens, that we would try to get the bulk of these projects constructed and underway for protection of the system.
Thank you.
Thank you. Item 5.
Item 5, request approval to utilize district's option to renew contract number 11-0130117 hauling services for stone riprap for 1 additional year under the same terms and conditions. We will begin the process of advertising for these services, but we're using the option for extension of 1 year.
It's going to take that long to advertise?
I'm sorry, sir?
It's going to take a year?
No, sir. We're looking at the extension of 1 year while we have our process moving forward on it. It's whatever's within the contract limits of it, sir. And usually when we do the extension, Judge, it's because there's usually been increases in prices and costs associated with gas, so we try to use the language in order to try to keep the best dollar before we get hit with an increase on it.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item B, requesting approval to utilize the district's option to renew the following for 60 additional days under the same rates, terms, and conditions as to have no disruption of service during the bidding process, which is contract number 10-011-11-16A, hauling services for gravel, sand, or crushed caliche, and 2, contract number 10-011-11-16B, hauling of dirt with an option to load.
Move for approval.
Check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item 6 is a requesting approval of the final negotiated appraisal services contract approved for negotiation by the Board of Directors 11/06/2012 with Leonel Garza and Associates for the West Main Drain Extension east of Ware Road and 9 Mile. That is at a cost of $2,000 for the appraisal services of that parcel.
Move for approval. Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item B, requesting approval to enter an agreement with Fastenal through the district membership with TexMass contract number 1151V020 for the use of the Fastenal vending solutions. Basically, it's where they can come in there and individuals with their ID cards can punch in and get a glove or get whatever they need to instead of tying up the bins, which keeps track of how much they're using and who's using it.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item 7, request approval of change order number 1 on the contract with McAllen Construction, Inc. for the J09 drainage improvements, Phase 1 irrigation siphon. Basically, we found an irrigation line that was a private that needed to be adjusted, and the change order of this project is $2,926.07.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
We have no item in executive session unless the board wishes to entertain one.
Move to adjourn. Second.
Those in favor indicate by saying aye. Aye, motion carries.
Thank you very much, Judge Commissioners.
Thank you, sir. At this time, we would convene a regular meeting. We would convene a regular meeting of the Hidalgo County Commissioners Court for today, November the 20th, 2012. President R. Commissioner Palacios, Precinct 2, Flores, Precinct 3, Palacios, Precinct 4, and myself, we have a quorum. Please join us in our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Jaime? Can you lead us in prayer?
Almighty God, we come together today for the good of the citizens of Hidalgo County. Give us your wisdom as we make decisions that will affect them today and in the years to come. Help us to work well together, recognizing that each of us are here because we want what is best for Hidalgo County. We ask your blessings and your guidance. In your name we pray. Amen.
Any concerns with the consent agenda, Mr. Ufraza?
I don't have any concerns, Judge. If no one else has, recommend for approval.
So moved.
Need a second?
Second.
Those in favor indicate by saying aye. Aye. Aye, motion carries. All right, the first presenter is Mr. Frank Craver.
Good morning again, Commissioners and Judge. I always thank you for letting us appear. This is something of a momentous occasion. You forced me to get up early this morning, but it's nice to be back on the front of the program again. But I would sincerely thank you for all you do in making it possible for us to express our views. This morning I want to bring a little old news to your attention. The Lower Rio Grande Valley Development Council is in the bus business. They report their results as all transportation industries do to the Federal Trade Commission. In 2010, the expenditures here in the valley for that one bus system was $2,186,414. And for that over $2 million, they collected fares of $90,551. That left a loss of $2,095,863. So their fares covered 4% of their operating costs, one of the lowest performances of the close to 600 bus systems in the entire country. And there's a good reason for that. They're attempting to provide mobility to what was admitted to be one of the poorest areas in the entire country. So the money is well spent. It doesn't mean that they're not doing the right thing. But I would like to bring something to your attention now, rather than old news, as new news. This is a research report comparing public and private bus transit services. I'll quote about 6 sentences out of the executive summary, and I think these are important. In theory, competitive contracting for bus service should lead to lower costs, but in practice, can privatization of mass transit actually save communities money? This case study presents one example in which substantial cost savings were achieved in the San Gabriel Valley of California. The use of competitively contracted bus service resulted in long-term savings of between 24 and 43%, with no evidence of any deterioration in service. Ridership is now 14% higher than had been projected for the public operator. This result is consistent with a growing body of evidence that competitively contracting for bus service is significantly less costly than monopolistic public provision. In light of the advantages of competitive contracting, it is surprising that more municipalities have not embraced privatization. Now, the point I want to make here is that we have spent an awful lot of time over the last several years looking at passenger rail service. And what I'm hoping is that commissioners will take the lead and get out front and put aside this following a dream which is totally impractical, that would be impractical financial suicide, and there's never any possibility. We don't have the demographics which would support it. We would be one of the worst places in the country to even look at passenger rail. So I hope that commissioners will take the lead, establish the policies, and guide everyone in this area to look towards improving bus service, which essentially we're going to have to stay in, and it's so important that we organize our efforts on things which are practical. Thank you very much for letting me speak.
Thank you. Next presenter is Lydia Jeffries.
Good morning, Judge, Commissioners.
Good morning, Ms. Jeffries.
I only have to say thank you to all of you and Commissioner Flores for the gift he gave me to get my glasses. Now I, in peace, go and continue to my journey. Thank you very much. God bless you all and your family. Thank you.
All right. Thank you, Ms. Next. Next presenter is Fern McClarity.
Good morning, and I would like to thank y'all for putting open forum back in the first of the Commissioners' Court so the public can speak. And the two things that I'm going to speak on and question today are on the agenda. So this is just to let you, I know you can't answer me, but you'll be able to think about it before you take the vote. This was placed on Facebook by a county employee. It says, tomorrow on Tuesday, November 20th, 2012, the Hidalgo County Commissioners Court will undo the county's classification and compensation plan. The county will return to the dark ages where politics will overrule fairness and reason in employees' compensation. Salary and job description will be developed on an anytime basis to suit the person to be hired instead of the market value and the skill set for the position. And so it goes, RIP, and it's got CCP, which is rest in peace. In the paper, it had out of the 12 largest counties, Harris and Hidalgo are the only two counties who do not have a step-and-grade or a pay plan. Y'all are always going back and saying about different counties. Why are we one of the last two here to not do this and keep it going? Right now, we have clerk 3. All are paid the same salary. But if you cancel the step-and-grade, this will again be changed to fit the person, not the position. Why would we go back when we're so close to getting everyone to understand what the position that they have, that they're not able to have someone just add to the position, and then that can go to that one person or something. So we're just asking you to look at that and not cancel this and try to make it county-wide. Second thing I'd like to say, on the computer, they showed the new Commissioners Court, and I had a question on why we have Precinct 1, Precinct 2, Precinct 3, and Precinct 4 an office in the new building. I've had 2 or 3 people ask us, why would you need that? And then I think there's enough seats for 172 people. Who else will be using the court during the week other than just on Tuesdays when Commissioners Court is there? So that was some of the questions that were brought up to me, and I thought I would ask y'all. Thank you.
Thank you. Thank you. Next presenter is Mr. Lupe Chavez.
Good morning, commissioners, public, county officials in attendance. My name is Lupe Chavez, and I came today to speak about our Public Defenders Oversight Committee and the Indigent Defense Program. I did send a letter to county officials earlier. I'm a professional journalist and writer, and since 2009, I've been arrested 3 times by the city of FAR, and it's given me a unique perspective on our justice system. Apparently, it is possible for police officers, senior detectives, canine officers to commit aggravated perjury, tamper with witnesses, tamper with evidence, official oppression, right in the purview of not only a jury, a judge, but also Hidalgo County prosecutors. And this is a problem to me because 5 white prosecutors with knowledge that these crimes have been committed against an indigent Mexican-American defendant have not reported it to the bar, have not sought criminal charges for these serious crimes. And because this is a criminal enterprise, it is considered organized criminal activity. But no charges have been filed. Now you're probably wondering, well, this ain't our problem. We're county commissioners. But you know, it is, I believe it is your problem because we are looking into building a new county courthouse. Now, if cases involving these officers were to be new trials, that would be an expense to our taxpayers. If I were to go to the Hidalgo County Jail on a visiting day and give people documents and tell them, hey, ask for a new trial, ask for your trial to be transferred out of Hidalgo County, that would be an expense to our taxpayers. Now, I believe that the Public Defenders Oversight Committee, I don't believe I've seen any meeting posted. It says they meet twice. We have 2 officials on this body that are serve on that committee. I believe it should be mandatory for anyone the county employs to provide the guaranteed right of representation in our legal system, that somebody who's on the payroll that gets paid by county taxpayers should follow the state bar ethics, and it should be mandatory that they report any type of prosecutorial misconduct or any kind of criminal allegations such as aggravated perjury. Now that's when somebody actually takes the stand and goes out of their way to lie and suppress the truth. It's shameless. I have court documents, transcripts, and it's even highlighted in our, some of those jury documents actually have Post-it notes from county officials where these crimes occur. Now,
Mr. Chavez, the law allows you 5 minutes. You have 1 additional minute.
Okay, well, thank you. Now, I know we're not here at the county courthouse anymore, but where you guys used to have your meeting, there's pictures of all the county judges from the early 1900s. Now you see they're all Anglo, and then finally they became, we see it changes. Same thing in the county courthouse on the second floor. There's old pictures of the Hidalgo County Bar Association. You look in the 50s, 40s, 30s, 60s, they're mainly Anglo. And it starts changing when we have Mexican-American and women attorneys. So I think this is an important issue, and it's not going away. And I think that as county officials, you guys should have some oversight as to making sure that our courts seek justice and not injustice. Thank you for your time.
Thank you, sir. Next presenter is Karina Cardoza.
Hi, Judge, Commissioners. Just wanted to inform the public of several moves that will be occurring this week and next week, especially because the phone systems will probably be down and not necessarily up and running as fast. That's why we're doing this move during the Thanksgiving holidays to be up and running by next week. I would like to announce that the County Judge's Office, the Public Affairs Division, and Emergency Management will be moving this week to the new location located at 302 West University Drive. The Human Resources Department will be moving to 208 West Cano. And this is important for the public because I know they experience a lot of heavy traffic. The Fire Marshal's office, with their permitting and everything, they're going to be moving to 1124 North M Road. So we just wanted to make this announcement. We'll go ahead and post the changes on our website as well to inform the public. Thank you very much.
Thank you. Next presenter is Opal Billman.
Good morning. My name is Opal Billman. I was sued for divorce in May of 1996. Our community property is 72 acres of land with capital improvements. For a settlement, the 275th District Court divided $650,000, which still had to be earned and had no relevance to the value of our community property. In transparent bait and switch, our existing real estate was switched to non-existent cash by the 275th District Court, who then appointed a beneficiary for our real estate. Do you want a state-appointed beneficiary? And where is the law that says they can? There was no change in ownership of our community property. It is still owned by Joe and me. Joe died April 24th, 2003. Under law, that means the case is dismissed from further judicial consideration. Ended, closed, over. 9 years ago. The 275th District Court refuses to dismiss the case, thereby keeping it active for the purpose of hanging on to our real estate for the state-appointed beneficiary. December 9th, 2010, the 275th District Court scheduled a hearing to dismiss the case. The court did not dismiss the case. It just set me up for another unconstitutional trial, which didn't resolve anything. It just still leaves everything pending upon my death, at which time everything that Joe Billman and I worked for and own would be handed over, not to the rightful heirs, which is the law, but to the state-appointed beneficiary, for free, of course. Everything that has happened since I was sued for divorce is unbelievable. The 15 years of false imprisonment in the United States of America is outrageously appalling. The 5th and 14th Amendments to the Constitution of the United States forbid it. When I filed complaints with the State Attorney General, his advice was to retain my own lawyer. I contacted many lawyers. My effort to retain a lawyer never got past the receptionist, who said the lawyer was too busy, or it was not what he did, not his specialty. No lawyer is going to tell the state of Texas that the state cannot violate the Constitution. The court's solution to my false imprisonment is to take my home away from me. For free, of course. Shuffle me off to an old folks' home, and since Joe is already out of the picture, and the court gets to take over everything we own. For free, of course. Joe and I did not get our community property for free. Joe and I earned it. It took us 45 years. Nobody else anywhere can say that about our community property. I have asked many times in the past 15 years for the false imprisonment of me to be ended. Once again, I'm asking those who took an oath to uphold the Constitution to honor the oath and allow me the right to life, liberty, and property every American citizen is entitled to under the Constitution of the United States of America. Thank you for your time.
Ms. Billman, I just want to make sure, once again, that we advise you that this court has absolutely no jurisdiction in the matter. All right. Yes. All right. Item 6A.
Good morning, Judge Commissioners. Michael Lee with the County Judge's Office, Economic Development for Bobby Villarreal. Item 6A, discussion, consideration, and approval of amendment to guidelines and criteria for granting tax abatements in Hidalgo County under Chapter 312 of the Texas Tax Code. We're bringing forth 3 changes for consideration. The first no longer distinguishes the difference between a lessor or lessee. Under current guidelines, the lessor, the owner of the building, would not be entitled to the same amount of abatement as the lessee, which is a company that we're trying to bring down to Hidalgo County, unless they meet the same criteria. Many of these lease contracts have a triple net lease, and the responsibility still falls on the lessee. So applying the tax abatement percentage straight across the board for both will still benefit the lessee. The local AEDCs are strongly in favor of this amendment. The second would be the maximum tax abatement right now is at 80%. There was a project that was presented in executive session with Bobby Villarreal regarding a company with a capital cost of over $650 million. We are recommending amending guidelines to allow a tier as requested by company and endorsed by the City of Edinburgh. This would allow a 100% abatement during construction with a maximum of 4 years and a 10% annual reduction until year 10 with a floor of 40%. In order to keep this offer limited and not open it up to every company, it is restricted to projects of extraordinary impact, and those are that have capital cost of $25 million or they create over 500 jobs. The last change has to do with timing provisions. Under current guidelines, a company cannot, in some cases, they can't begin their project, acquire land, or sign certain documents until the tax abatement is approved by the court. Because of the lengthy process, much time is lost and the guidelines inhibit the commencement of some projects. So we are recommending amending the guidelines to allow projects to take certain action, such as commencing construction, so long as they know that they move forward at their own risk. The final abatement still needs approval and is at the discretion of the Commissioner's Court, and they can only start the process after a completed application is submitted to the county. This has been, all recommendations and revisions have been approved and drafted by legal. We sent them to the auditor's office last week, and they all supported all by the local ADCs. So at this time, we're asking for your approval.
Steve, did you go over?
Our office did.
And
it's a business decision for the court. These amendments really are being prepared for one company, and it's one that we've discussed.
Well, the
before.
first one applies across the board.
Right.
I mean, what it is, that the abatement right now, as we presently have it, applies to the applicant, the lessee.
Correct. Well, there's lessor and lessee before. What they're doing is they're making the same requirements to both lessor and lessee.
Right. They're trying to apply it to the lessor. But that's across the board, not just to a particular company, but from here on out.
Well, that's my point. This will be effective from here on out.
For everybody.
For everybody.
Right.
That meets the criteria.
Did you say it was 65 million or 650 million?
650 million, 650. On that one project in particular, yes.
Yes, on that power plant?
Yes, sir.
I mean, we need to encourage, do whatever we need to do to to encourage them to locate here in this county.
Is this the only change to you?
There were three
There are
changes.
three of them, Commissioner.
One on.
Let me get it.
So again, we're asking for your approval at this time.
That's on that power plant. So if we don't let them build it here, they'll go Cameron County.
They'll go to Cameron.
Wellesley County or somewhere else, no? Steve, what's your recommendation on this?
Like I said, it's a business decision for the court to make.
No, I understand, but is anything being done illegal?
No, it's not illegal. It's just a question of well, it really comes down to, like I said, a business decision for the court.
Well, I understand. Right now, it's raw land. It's worth Farm Act, probably.
Right. I just caution you that
Yeah.
you can't look at it really as an individual project by project
No, I
basis.
understand that. We need to do it for everybody.
One of the reasons that, so we don't open it up to every company, it is restricted, like I said, to extraordinary projects that have a minimum of 25 million, or they create at least 500 jobs. And in all honesty, we don't see those too often.
And if they come, let's welcome them.
No, most definitely.
Any questions, Commissioner?
Mr. Ofracio? What do you think? About this?
Changing the guidelines? Are you reducing the requirements, or?
What's the main difference
Not sure.
between what we're doing now and the change?
One of the things that we do, we do an audit every year of the abatement guidelines.
To assure the compliance?
Sorry?
To assure the compliance of...
Yeah, for compliance, yeah, and we send a letter to the appraisal district, because they're the ones that control the percentage of abatement that the companies qualify. So we audit and we send them a letter saying the company qualifies for X percentage based on the capital improvement amount or number of jobs.
During the construction period.
Okay, another question I've got. After 4 years, they're going to be taxes on $650 million.
They're investing $650 million. It has to do with the building itself and also personal property as well, but still taxable.
So that's going to be the tax.
Oh, a tremendous tax increase for the county.
The benefit in this case of the type of business that they're bringing in, it's not like we're taking in another $600 million worth of assets such as subdivisions and stuff where we'd be required to look at infrastructure, we'd be required for police protection. These are they're very, we're in a very beneficial position if we can offer the incentive for them to locate here. Obviously, the economic impact is a job creation, and obviously the tax base is going to give Hidalgo County without the burden of all the other things that we'd have to address if it was in another manner. But I stand in support of it. We often have to look at these incentive packages and take them case by case. And in this case, it's a clear benefit to Hidalgo County, for the people of Hidalgo County.
Commissioner, I'm sorry. I thought
No,
you were
that's
through.
fine.
No, Commissioner Tito Palacios had a question. We're giving him 4 years for construction. What happens if they don't construct it within 4 years? Does it revert back?
Well, we have talked to Deborah Legal about that, like a reverter clause, but I think that might be more of a legal question. If we can get some assistance there, Steve.
I think based on what the contract says that they have 4 years to construct and they do not.
And it's a maximum of 4 years. The other thing is if they finish soon, well.
It's a maximum of 4 years that they would have tax payment during construction. If they leave after 3 years, they leave.
Because there's been some companies that come in and leave.
Correct.
For example, there's one in Mission, Crater Lake.
So it's null and void at that point?
As far as collecting any taxes at that point, yes.
How many jobs is it going to create anyways?
I believe it was 70 jobs with an average of about 70,000, I want to say. But this was more on the lines of the capital cost and the taxable property that it results in.
Bring about 14.
Judge, I think one of the things that you need to consider is that you're going to abate taxes, but those taxes are going to be less taxes coming into the coffers, and with the needs increasing, it's something that you got to take into account, whether it's cost effective for you to abate the taxes for those companies.
Okay. Any other concerns or questions? If not, I would entertain a motion to approve these amendments.
Steve, you recommend it's okay? Just a big business decision?
Legally, it's okay. It's a
Legally,
business-
it's okay.
Legally, it's okay. It's a business decision for the court.
And again, as a reminder, it is competitive. We are competing with other counties, so we are at risk of losing the project.
I guess move for approval. Second.
Those in favor indicate by saying aye.
Aye.
Aye as to all three amendments.
Thank you.
Thank you, sir. Let's hope that that company is encouraged and does open up here in our county. All right, next item, item 6C.
6B.
Excuse me, 6B.
Yolanda Chapa from the County Judge's Office. Last week, the judge appointed for South Texas ISD board members, and at this time, we are bringing forth Dr. Richard Fleming, which was already appointed, but at the time that we brought his name forth, we did not have some information about him from his bio, and today we'd like to read that, the correct information that we received. Dr. Richard Fleming holds an AB from Washington University, an MD from University of Tennessee. He received his postgraduate training at the Mayo Graduate School of Medicine and is a founding member of THG, the hospitalist group in Hidalgo County. And the recommendation at that time, and it was approved, was for Dr. Richard Fleming, and he is here in the audience.
Dr. Fleming, can you please come forward, sir? Up here in the podium. We want to certainly thank you for your willingness to volunteer your time and talents to this board. That, as I understand it, that hospital group that you're involved in is not just confined to one hospital, but to several hospitals. You're the head of this emergency room group that provides emergency treatment at these various hospitals. And I understand you've got your children at this school district?
Yeah. My oldest son's at the STPA.
Well, we wanted to make sure the community saw you and became familiar with you and who you are, and that we publicly and formally thank you for your service.
Thank you. I appreciate the opportunity. It's an honor to represent the Hidalgo County on the board, STISD. I'll do my best to serve. Thank you.
Thank you, sir.
So moved.
There's no motion required.
No motion.
Richard, why don't you get over here and we'll take a quick picture here.
I'll take one from Mingo, he likes it over.
Thank you, sir. And item 6C.
6C, again, Michael Leo, County Judge's Office. Item 6C is in reference to the project that we discussed right now. It reads as follows. Recommendation for county judge to send correspondence indicating county's interest in Project STAR. Again, the letter was approved and supplied by legal, and we're asking for your approval at this time.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
All right, there's been a request to move two items to be taken out of order. The first one is by Mr. Rene Guerra, who desires we consider item 7D as in David. It's discussion, consideration, and action suspending the Hidalgo County classification and compensation pay plan for all participants of the plan. Mr. Guerra?
Commissioners, Mr. Fraser, Mr. Crane, Mr. Guerra. Judge, I would like to be taken off the stepping grade reference to my office on salaries and what have you. It hasn't worked for our office. There's a lot of people that are not under stepping grade, and I believe that because of the salary inequities, if it's not working, we should try something else, or at least go at it later on when maybe there's a better consensus of all the judges, all the commissioners, and every department to join a comprehensive plan. Initially, I was for it because I felt that was good for the county, but I don't know that we all got the same information when we made the decision to join.
Well, having some kind of structure is good for the county, and we're still trying to fine-tune it, though. We've been meeting with, I know with Victor and Josie and some other people talking about what we can do to fine-tune and tweak it a little bit so it'll make some sense economically, and we're not there yet.
I don't think that under the system that we have right now that you can tweak it, Judge. I mean, you have a lot of employees that didn't have to go to law school, didn't have to go to a graduate school, and they're making more salaries than some of the seasoned lawyers that I have in the office.
I totally agree with you, sir. That's why I think we do need some structure, but the way it's set up right now, I think it's going to be too expensive, too costly, something that we probably cannot at this time afford, but we need to start putting something in place. And we are, I want to assure you, I am working with various individuals here in the county to try to do that and bring it back up again.
Well, there's also a statute that says that the DA will set salaries for your staff, that I gave a copy to every one of you.
Well, but that statute does say that the prosecutor shall set the salaries, but subject to the court.
Yes.
What we can afford, in other words.
Yes.
But I do think.
No, I understand that. I'm not given the freedom to set salaries that I believe that I should set. The salaries are being set artificially by a chart that hasn't worked for the last 2 years. Okay?
I personally think you're not paying them enough.
I know.
But I agree with that.
But every time that we have budget workshops and whatever, and they say you're stuck with no salary increases for the year, and if it weren't for some of the soft money that I've gotten from drug forfeitures and check fees, I would have already lost at least one good third of the professionals that I've been able to maintain.
I can see where people with doctorates in law, it took them a long time to obtain that degree, to start them off, and I think you got it at $52,000 or $49,000.
Yes.
As a starting salary. You're not going to be attracting too many people.
Well, and the entry points vary from county to county. The problem here is that when you train a lawyer, after 2 or 3 years, we lose them because we can't compete, or they can't pay their educational costs that they had to go out and sacrifice. And I've lost many of those already.
No, I don't think it makes any sense for us to start off and pay these people that kind of salary and then pay other people that don't have that educational support or educational background, paying them in the mid-60s and 70s.
And I'm not against people earning whatever they can get, and I'm not envious of whatever somebody else does. The problem here is that over the years, I've tried to hold the line on what was reasonable and work within the confines of the commissioner's budgets. But when you see people you're supposed to have bailiffs in courts that are supposed to be certified peace officers, they're not certified peace officers, and they're wandering around, and then a constable gets jumped because he doesn't provide security in a courtroom. Now you see some of the problems that you all are not addressing. People are allowed to take salaries from several positions that you all had said before. One bailiff, one coordinator, one assistant, and what have you, and that's not being complied with within the court system, and they don't want to join the stepping grade. So these are inequities that I think make it very unfair to all the employees that are on stepping grade, the district clerk, the county clerk, and the DA's office. Now, the sheriff's office is in a separate department, and he has his own stepping grade, and he can get whatever he needs to get, which is okay. I'm not begrudging anybody getting what they can get from you. The problem here is there's too much inequality on salary setting. There's some departments that I think shouldn't even exist, okay? But I'm not going to here to point them out.
Judge, if I may, I think the intent behind the reason for implementing step and grade is not necessarily to increase the cost to the county. Sergio can.
The intent of step and grade is good. Problem is, nobody's carrying it out except the people that made that sacrifice.
It's a starting point, Mr. Guerra. And two wrongs don't make a right, and I understand, and I agree to some extent with your comments. But Judge, you mentioned that it would cost the county too much money to implement. Sergio.
The bottom line here, Commissioner, is it's not going to be fair for his employees once we start on step and grade, because they're going to be making 49, and that's where they're going to stick. And the other guys here are making $70, $75, $90,000, and they're going to stay there for the next 25. He's been losing his people every 3 months, 6 months, 2 months. Sometimes they just come and get trained in, and then they leave. I know.
Well, I spoke to Mr. Guerra earlier, and I agreed with his comment regarding the pay. I've asked him to cut the cord and make a request to adjust the salary of his staff. And he gave me several instances where a comparison, and I agree with him. And I would invite you, Mr. Guerra, to come back to court and make a formal request for adjusting some of your salaries for your staff. But as to the cost of implementing the step and grade, I don't think there's any anticipated cost.
That's correct, Commissioner. As far as when we implemented Phase 1 and Phase 2, there was no additional cost to the county the way we implemented the plan, and we don't anticipate any anticipated increased cost to the county for Phase 3. However, it's up to the court as far as what they would like to do with the classification plan.
Can I ask a simple
Yes,
question?
sir.
In this case, when you're applying that rule, let's take just the DA's office into consideration. What do you have the salary under that system set at currently?
Currently, I believe an attorney 1 is a grade 14.
Which pays?
Which pays about 48.
Which is, and see, that's the
minimum
argument. I don't think we've been, and the committee's done a great job. Our efforts have been wonderful, but I think there's been, I don't think we're there yet on a perfect system, because the argument is very simple. If we apply it, it still doesn't take care of the problems that we have, taking the DA as under consideration for a starting attorney. And we all agree with that. I think that it's unfair. If we're looking and considering about suspending, whether it's the DA's office, district clerk, then we have to do our due diligence and get behind it. I don't think anybody's advocating non-structure, because I think that that's what got us in this place for the first time. Yes. But we're applying something that already doesn't work for respective departments like the DA's office, and then standing behind that when we didn't really do our due diligence to fix it at what would be ideal, or not ideal, what would be market level for an attorney. That's the problem. Those are going to be the continued arguments that are that we're experiencing. So it's my position that we have to obviously fix it, and continuing on under that model is problematic. It's going to continue to be problematic until we adjust it.
And we do have policies within the plan, such as a regrade policy, to where we can regrade an attorney 1 position from a grade 14 to a grade 16 based on market analysis, based on the department's input and research, market research. So we do have avenues within the plan that would be able to help us correct some of these inequities. However, we would need to, it would take some time for us to go and do the market research and see what the starting pay should be currently.
Why couldn't we suspend this? Say a year from now, come back, get everything ready before we even present it to Commissioner's Court, and here it is all at once. Instead of having one department here and one department later and a year later. I mean, we need to suspend all this, fix it, get everything ready, and bring it all at one time.
There's still a safe.
But, you know, I understand the district attorneys, need to make more money, those prosecutors, because we're losing them left and right, just like we did with the sheriff's deputies, remember when we were losing them?
Yes.
We were losing them.
Right. You know, he's providing a training ground, and once they learn what to do, what they need to do, then somebody else picks them up in the private sector.
Just one example that I was going to give you, Judge and Commissioners, with the example that Mr. Cruz gave. If you're going to modify a position, in our office at least, it's a 2-grade jump. A 2-grade jump in salary is somewhere between $8,000 and $10,000, which we can't justify. So the classifications need to be modified in addition to the salary schedule.
Yeah, the safety guard is still in place. We got Commissioners Court ultimately to make a decision. We understand the model. I think we have to do our due diligence to stay within the model, adjust where there need to be adjustments, and then make sure that there's a unified plan that all the way across the board we curb all the arguments that are out there. So there's still a lot of work to be done. It would be unfair to keep them on the system as opposed to some of the other departments and all the other departments. But court's going to have a daunting task to, I guess, address the issues as they come up and to assure that they're right in line with step one, whether we're applying step and grade or what's based on the market. But I think we do need to suspend until we refine it.
Well, move for approval and suspending.
Second.
No other questions? Those in favor indicate by saying aye.
Aye.
Aye. Motion carries.
Opposed?
Same sign.
Aye.
Motion carries 3-1. All right, the next item that we're taking out of order is item 19B2, a report by ERO Architectures.
Judge, may I approach the Commissioner's Court?
Yes, sir.
I guess for the judge, and it's for you. I'll give them to him.
Good morning, Judge. Brian Godinez, a member of the ERO Architects team, along with Eli Ochoa.
All right, Marty's behind you, and it's her department.
No, that's fine. I just want to announce that. Martha Salazar for the Purchasing Department. We will be discussing 19B2, which is the presentation by contracted architect ERO for acceptance and approval of the Hidalgo County Commissioners Court of the Comprehensive Master Plan Report, its ancillary functions, including conceptual cost estimates, stakeholders, facilitations, and implementation strategies. And Mr. Godinez is going to be making the presentation. And Mr. Ochoa.
Thank you, Marty. Thank you, Ms. Salazar. In front of you is the final printed document of the County Courthouse Master Plan. That is this book. And then also in front of you is a copy of the Historic Preservation Plan, which is this book. Several weeks ago, we came before the court with a presentation outlining various elements of the master plan and the Historic Preservation Plan. We asked for your feedback. We got some feedback and informed the court that we would come back with a final printed document for record purposes, as well as seeking your possible adoption of the documents before you.
Who is Linebacker and Godfrey Architect?
They're an architectural firm that specializes in historic preservation planning and programming. They have a lot of experience with historical Texas State Historical Commission.
Were they working under your contract?
Yes, sir, they were. That was one of the deliverables, that we would give you a historic preservation plan in the event, because the courthouse qualifies under the preservation of historical buildings. In the event that we decide to remediate and renovate the existing courthouse. These would be the guidelines that we would follow under the statutes and rules and regulations of the Historic Commission for the state of Texas.
Judge.
It is required, Judge, by the way.
Yes. Yes, sir.
I have a question regarding to the contracting of ERO. Marty, what was the responsibilities of ERO architect? Were they going to develop construction plans for the potential new courthouse?
No.
It was an assessment.
We don't have the construction.
No, I described what I have on my caption is what the extent of their scope of work was on the master plan.
Right.
So this is being done under the master plan.
Right.
There has not been a selection of an architect for the construction of a new courthouse.
So they just presented to court?
As part of the scope of work of the original engagement for the master plan scope of work.
Okay, all right, thank you.
Okay, so that's what this is being done. This will finalize that contract, which I believe has been finalized also through payment, correct?
That's correct.
Okay.
Yes. I believe the original, this type of document had been presented at a workshop.
We've presented it several times.
Correct, but never
to the commission.
formally accepted
Right.
by the court.
Right. You
So
came
the
back
court's
in,
been
I
made
think it was
aware.
early October, wasn't it?
Yes, sir.
I know that it was, but it was not an official action.
It
meeting.
wasn't bound and
Well,
presented
but there
in
was
that
no
manner.
action at that meeting.
Correct.
But I think initially they were hired to do
An assessment of the
as-built
existing.
plans for the existing courthouse, right?
But that's a separate.
That's a separate
That's a
contract.
separate contract.
Right, oh, it's a separate contract?
Yes.
Okay, I
Yeah,
thought this
there's
was
two
part of
different
it.
contracts we're talking about.
Okay.
Okay?
Thank
There
you.
was even a third one that was never finalized, and that was for the possible construction of an additional building at the Robert Chevrolet property. But we've never finalized that because of the looming results of the master plan. Okay? Thank you.
Are there any questions from the court?
None. Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you all very much.
Judge, just a simple question. Obviously, we did an assessment of the building, the existing courthouse. We have a master plan. What is the will of the court? Or obviously, the problem's not going to go away. We've had many calls from many constituents and elected officials and in the judicial capacity about wondering where the county's going next. Obviously, it's not going to go away. We see the modulars being put up. It's going to be something that we're going to obviously plan on addressing it from a permanent standpoint.
Certainly, and you're still leasing, you're still having to lease on other very important departments of the county that we have nowhere to put them.
Well, space is a premium at this point. We've been talking to the city of Edinburgh, who has offered us their
Contribution?
What percentage? I'm trying to remember the percentage.
I heard
Or
a
the
figure
figure.
of 20 million.
No, that's for the construction. I'm talking about for the preparation of the plans.
Oh, it was
The next-
200,000.
The way I understand it, the next phase is they're going to work, whoever we hire as architects.
Next phase is selection. Either the nomination of firms from our pool or a project-specific RFQ for the engagement of an architect.
And they're going to prepare the specs.
Well, who's ever engaged is going to do the entire thing. I don't believe you're going to get any architectural firm to accept on a liability issue work from another firm.
Well,
At least
but
I would foresee that to be a problem.
The point here, Marty, is at the next time we award a contract, we're not awarding a contract for construction of the building. We're awarding a contract for an architect to develop the plans, the specs, as to what the building is going to look like, so that we can then let that out to the contractors and
Yes,
they'll
sir.
come back.
But your next
Give us a
step
bid.
is the selection of an architect.
Okay.
But what I'm saying is I had been approached on possibly limiting the scope of engagement of an architect to a couple of phases only. And that's where I said the court, I do not believe, I think that would create problems for the court. I think you need to engage an architectural firm to do the entire,
And the city of Edinburgh has offered to help
about
us
200,000 for.
200,000 out of whatever the cost may be.
Well, I think they had put a cap on their contribution. I may not be correct, but that's their contribution to what I remember.
Correct.
Toward the architectural service.
Right.
Okay?
In answer? Yes, sir.
What else would the court decide to do? I think we need to set some deadlines. Otherwise, we're going to drag it out for the next 10 years. It's something reasonable that we can set a timetable. I think taxpayers would be very much interested in finding out what's going to happen.
And you're correct on that, Commissioner, because it took the jail several years before somebody came in and built it. I mean, it should have been built 12 years before.
Well, we had been under a remedial order for how many years?
It's over and done. Now it's time to act.
In other words, I think the consensus is that you set it on the agenda for us to award that contract.
Well, to nominate the firms.
Hold on, Marty. The contract for the awarding, to begin the specs and the design of the building plan, the plans.
Correct, but what I'm saying, Judge, is I can place it on the agenda for the nomination of at least 3 firms from our pool, or a project-specific RFQ for the engagement of an architect to do exactly what you're asking. So you need to that's the first step after this.
What do we do?
And I believe
you've got a pool of architects, so you can either select from their pool or
nominate
do
for the
an
pool or
RFQ.
put out an RFQ for a specific, project-specific for a courthouse engagement of an architect for the design and construction of a courthouse.
In your opinion, what method would allow us to get the better price, so to speak? The one that would allow us to negotiate?
Well, either one, either one. But if you want to shorten the process, you've got a pool of quite a few firms. You may want to narrow the pool down to those who have experience in your larger government buildings, that type of situation. Or just, we'll put it on the agenda. We will mark those firms that do have the discipline toward those type of larger facilities, and you nominate at least 3. That's what our protocol is. And from there, they'd have to be scored and graded.
So the choice is nominate 3 or to just
Or put out
designate a
an
project-specific
RFQ, request for qualification.
Marty, can you put both of them in the
Yes.
agenda and we'll just pick?
Yes, sir, I will.
Yeah,
I
go
will.
ahead and do that. I think it's
So,
better.
do you want this for next Tuesday?
That'll
Because
be
the
fine.
agenda officially closed yesterday.
Well, you can add it on.
Okay. I want everybody to hear that because I'm always blamed for putting things on the law at the end. I'll be glad to put it on.
At the
It'll be on-
direction of the court, you should add it on. So
Yes,
we
sir,
can
I
consider
will,
it.
I will. All right. Thank you. Yes, sir.
Judge, just one more point. Because the City of Edinburgh was part of the master planning process, we're going to be presenting tonight at their 6 o'clock council meeting. We're going to be delivering a set of books for the council members as well and the city staff.
All right, sir.
I do want the court to realize that not necessarily at the phase we're going to put on for next Tuesday, which is the nomination of the firms, but at the point that they're ranked and evaluated, scored and ranked, funding will have to become an issue for the court.
Well,
Funding for those services.
Right, well, but funding not for the construction, funding for the architect.
Exactly, for those fees.
Yeah.
You gotta have funding for the whole thing, in my opinion.
Well,
Pero la ciudad va a
but
tener 200.
it could be that after the architect is engaged, the court may decide not to proceed
Well,
with
we-
the courthouse. I doubt that that's
we
going to
can
happen,
rank 'em.
but at this
We
point.
can rank 'em.
Oh, you can do
And
that.
then-
I'm
and
just saying
then-
at the point you finalize an agreement, funding is going to be an issue.
Exactly, but we can rank them and.
Right.
and-
And to that funding end, we know that the city of Edinburgh is ready to contribute $200,000.
All right.
All right?
Thank you. Thank you, gentlemen. Let's move back to item number 7, Mr. Guerra. Who is not, is Balde around?
He's watching you on TV.
Is Mr. Sunday here?
Yes, sir.
Why don't you cover the item 7B, status of those portable buildings?
Not an energy.
Rick Sunday, Infrastructure Division. Ramtech is 98% complete on the interiors, and I believe, Mr. Guerra, do we have the...
I've got the acceptance documents, Judge, and that's on the, on 7B. We've got acceptance documents with respect to a punch list. Mr. Sunday has reviewed the punch list. Mr. Sunday has said that they have complied with the couple of little things that needed to be done. Downspout needed to be installed in one area, interior door closure, switch out.
When are those buildings going to be ready to be occupied?
January, Judge.
Early to mid-January. We're on target.
Yes.
Very good. Thank you, sir.
So, Judge, with that being said, I'm sorry, Mr. Sunday, I do have the acceptance documents, so I'd like authority to sign off on the acceptance documents for Ramtech based on the walkthrough that Mr. Sunday has done with Ramtech, and Mr. Sunday is satisfied that the punch list was complied with.
All right. Need a motion for that?
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye. Motion carries.
Thank you.
What was the action on? Judge? What was the action on?
Balde, what did you call that certificate?
It's an acceptance document by for Ramtech Building Systems. What I can do, Judge, is again, based on the action item that we have here on the presentation, I'd like authority to sign off. Now, what I can do is, so that we can have a record of the document on the agenda, I'll put it on for next week again.
Steve, is it proper to take action on an item that is not listed on the agenda?
Well, the way the agenda reads, that's what I was talking to Baldy about. I don't think this action is proper because it wasn't publicly disclosed on the agenda.
I'll have it on for next week.
We have to bring it back.
That's fine, I'll have it on for next week, but I did want to make, we do want to inform the court that the punch list has been complied with respect to Ramtech Building Systems. Judge, there is no action under 7A, 1 and 2 unless we need to take action further down the agenda. Item C, I'm asking for our Deputy Fire Marshal to attend a forensic analysis and fire dynamics seminar. This will be November 28th through the 30th at the island.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye. Motion carries.
And just to finish out the agenda on my part, there are no emergency situations occurring since the last agenda, so there's no action on that.
Balde, yes?
That's all I had under item 7, Judge.
Okay. Sheriff's Office, item A.
Good morning, Judge. Good morning, Commissioners.
Good morning, Mr. Garza.
Lieutenant Rafael Garza with the Hidalgo County Sheriff's Office. We have 3 items. ICE overtime. Item number 1, approval to accept overtime funding from the U.S. Department of Homeland Security, Immigration and Customs Enforcement, ICE, in the amount of $15,000.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye. Motion carries.
Judge, and just for the record, that should include the approval to pay the overtime. On the current policy, employees can only bank overtime, but since you're going to get the grant funding to pay for the overtime, it's implied that you're also approving for those employees to receive
But it can be included on
paid
the...
overtime.
Yeah, we'll let it be included for the
That's for the
record.
record.
Thank you, sir.
Thank you.
May I continue? Yes. Item number 2, approval of certification of revenues as certified by the county auditor for ICE overtime funding.
Move for approval.
Second.
And that would go to
For 2 and 3.
Yeah.
Those in favor indicate by saying aye.
Aye.
Aye. Motion carries. Thank you, sir.
Thank you, Judge. Thank you.
Item 9, our DA's office.
Morning, Judge, Commissioners. We're requesting approval of the 2012 Chapter 59 Asset Forfeiture Report.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Number 2 is approval for County Judge Ramon Garcia to sign the asset forfeiture report.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
B1 is approval to create a part-time coordinator 1 position.
With no grade. Move for approval.
Second. 1, 2, 3.
All right, what's the salary amount? Do you have it handy?
No, it's 15.64 hourly.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And approval of inter-department transfer.
Move for approval on 2 and 3.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
Item 10, our Health Department.
Good morning, Judge, Commissioners. Item 10A, sir, there is no discussion on that item. Item 10B, sir, I just want to give an update real quick. We submitted our plan as indicated last week by court. We submitted for over $235 million worth of possible funding to come down here to assist us with health care services in our community in partnership with the various counties and entities within our county and within the neighboring counties to assist us. We are looking at submitting Pass 2, which is the next level of funding, by the 16th of this month. Request, hopefully maybe we might generate close to about another additional $50 million that could be matched. We're still working on with the University of Texas on that. Those are the IGT partners for that.
And if that funding is approved and when we get it, it'll cover what period of time?
It'll go over the next 4 years, sir. It'll go over the next 4 years.
That
35 million. Yeah.
Initially, you had said it was going to be about 800.
But we couldn't get the IGT to match it, sir. We needed to come up for every $1.50 the federal government gave us, we needed to come up with $1. So we were only able to come up with approximately 135 million to match to create the 235 million.
Isn't that where that situation that the hospitals were going to tax their beds or something like that was going to come into play?
Sir, right now there's some pending legislation to be looked at. Senator Hossa is taking the lead on that. Depending on the outcome of that legislation this spring, we'll determine whether the development of a health district or some type of mechanism to generate additional funding to be matched will be determined, but that's yet to be approved by the legislation.
So in the future down the road, is there still a chance to increase the IGTs?
Unless we come up with more local funds to increase the IGT, there isn't. I got a feeling once everyone starts seeing this program work and seeing what it does to the economy and the community, I got a feeling we're going to start seeing some of the cities and getting more involved with this. Now, the trick to this is that we are only going to be given one more chance to add programming to this coming year. After that, it's fixed, and that's just the way it is.
So do you think legislation will?
I think legislation will help a long way, sir, if it passes. But yet to be determined.
You need action on it, right?
Pardon me?
You need action on this?
No, sir, that's just a discussion. There's no action on this, Mr. Commissioner. But I just wanted to give you that update, Judge and Commissioners. Item C is pursuant to Chapter 121, Local Public Health Reorganization Act, Section 121.06, requesting approval of fees for public health services. So we just needed to get this formalized, and these are the fees that we charge at our clinics for some of the people who do not meet federal guidelines or state guidelines, and these are the different co-pays. We're following our auditor's recommendation and his team's recommendation to have this formalized and put on record, and we'll bring it back every year for review, but this is a step that we need to get on the record.
Second.
And are the fees, are they in line? Are they fair?
Oh, yeah, in fact, the fees are very fair. In fact, they are less than Medicaid rates. This is basically just cost of the service plus a small administrative cost. The fees are very competitive and not as great as you would find in a hospital or a different place like that. Because remember, the people we see have nothing.
All right,
they have nothing.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Okay. Mr. Frasco, any questions on that? You're okay with that?
Yeah, I'm okay with it. I was just wondering, there was some analysis done, you saying, to establish the fees?
Pardon me?
You did some analysis?
Oh, yes, sir, yes, sir.
to
Yeah,
come
there
up
was
with
we compared it to other FQHC, federally qualified health clinics. We've compared it to some of the local areas. That's what we looked at. We compared them.
Thank you.
Thank you, Judge, Commissioners.
Thank you, sir. Item 11, our Fire Marshal's Office.
Good morning, Judge, Commissioners.
Morning.
Discussion on the current status of the San Manuel Fire Department. As you're aware of, on the 15th, we were supposed to have a vote on the bylaws. However, we had made some necessary changes to those bylaws, so the date has been changed to December the 3rd. Once they are approved or disapproved, at that point, we can continue to move forward. Do we have any questions from the court?
No, just a comment. Obviously, we've been diligently working with the volunteer firefighters for Lynn Samuel Fire Department as well as the board members. Out of respect to the adjustments, we wanted to make sure we certify copy the new adjustments so everyone has enough time to review them before the vote on December 3rd. Everyone is supportive of the December 3rd meeting, so we just want to give you an update of it.
All right. How many board members are there going to be?
To give respect to the firefighters, we gave 2 additional, so it's going to be a makeup of 9 board members, where 7 of them are appointed from all the 3 stakeholders, which is the county. The second would be the ESD, Emergency Service District. The other one for that area would be the Lynn Samuel Improvement Corporation, and 2 board members coming from the volunteer fire department, firefighters. So we feel like we got a good composition of good representation to assure that there's a good checks and balances, and at the end of the day, where there's compliance on all issues that the county is concerned about, whether legal or auditor.
All right, sir. Thank you.
Thank you, Judge, Commissioners.
Thank you.
Item 12, our adult probation.
Judge, Commissioners, Arnold Patrick with the Adult Probation Department. On item A1, 12A1, I'm requesting approval to create a full-time clerk position under the drug court program.
Move approval of 12A, 1, 2, and 3.
And I read here where it says budgeted salary. It's already included in your budget?
The funding is included in, we have the funding, but we're asking to include it into the budget.
But the funding has already been set aside as part of the 2013 budget. Are these additional monies to your budget?
Yeah, go ahead.
Judge, adult probation doesn't go through the regular budget process with the county. They have their own budget.
Judge, these are from reserved revenues from the drug court fees that are charged. They're at the courthouse, so basically these are being paid from reserved funds. So we're asking to appropriate those reserve funds, and then we'll take similar action next year, at the beginning of the year, to appropriate from those reserve funds as well for fiscal year 2013.
All right, those in favor of the
Using
motion?
county funds, Sergio?
Judge.
Using county funds for this?
Yes, these are general fund reserve funds from drug course, drug court.
Sergio, I want to ask a question. With respect to the action then taken today, then next year you're going to have to take the same action so that the slot exists in 2013?
That is correct.
Okay. Then, Judge, Commissioners, with that being said, I just want to inform the court, then this action then would require us to meet either January 1st or the 2nd on a Wednesday to create the same position, because until the court takes this action next year, that position does not exist in next year's budget. And so that slot, until created, whoever you hire this year is going to be out of employment for that period of time. So with that being said, then I guess I'm letting the court know that if we take, I mean, I'm not saying that not to take the action. I'm just saying that we'll have to have a court session Wednesday or the 1st, January 1st.
But you already do that every year, because slots are created after the budget
I understand
is approved.
that.
So this is just one of those additional ones that you're going to add to the listing.
Well, I don't know. Is this the only one we have for next year?
I believe there's others that we've deleted, and there's some others on the agenda that we'll be changing the funding for them as well.
Okay, then and that's the point then.
It's impossible to approve that prior to the 1st, take the action, and make it effective.
That's what happens every year, Commissioner.
I agree with Mr. Guerra. To make sure that it works, you're going to have a meeting either on the 1st or the 2nd.
My question, not Mr. Guerra, the question is, can we take whatever action prior to January 1st, effective and make it effective on January 1st.
Commissioner, I'm going to have to check that.
I think they'll take care of all those problems.
But I have to check that to make sure we can do it.
Judge, but that happens every year whenever there's a position created after the budget is approved. Prior to the end of the year, there's an agenda item to approve all of those positions that were created after the budget was approved, effective on January 1st. And there's a listing of positions that are on the agenda. So again, this is just another one of those positions. I don't think you need a special meeting for just this position. Right, Sergio?
I believe the last 2 years, we've taken an agenda item just shortly before the end of the year, and we've approved all the actions that have been approved since the adoption of the budget, and we've approved them then, effective the beginning of the next fiscal year.
Well, our lawyer appears to have a question about it. I don't know if you...
I was going to check that, make sure we can do it.
Okay. We're going to do it subject to hearing otherwise from Mr. Crane.
Yes, sir.
Did we take a vote on it?
No, sir, not yet.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
The 1, 2, and 3, Judge?
Yes.
Yes, sir. Item 13, facilities management.
Judge, Commissioners, this is an application to initiate utility services at a new building located at 9805 North 10th Street in McAllen, Texas. This is part of our process, so I'm asking approval of the City of McAllen's public utility application.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
14, Urban County. Good morning, Ms. Sedna.
Good morning, Judge, Commissioners. Our first item on the agenda is a request for the approval of a resolution authorizing the submission of a 2012 Bologna Economically Distressed Areas Program, CDAP, application in the amount of $500,000. I believe the auditor had a question regarding this in the review of the resolution. Steve, can you tell me whether or not your office looked at it?
Yes, we did.
Okay, it was the same one as the previous year, so we're recommending the approval.
Move for approval.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item 2 on that item is the county judge to act as a county's executive officer and authorized representative in all matters pertaining to this 2012 CDAP fund application.
Those in favor, do I have a second?
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item B of the Urban County section is requesting the authorization to amend the Emergency Solutions Grant ESG contract with Catholic Charities. Catholic Charities had originally been awarded the amount of $170,531.25. We're requesting that amount be amended by reducing it by $18,880 and allowing Catholic Charities to continue to have $151,651.25.
Move for approval.
Second.
Those in favor indicate by saying aye. Aye. Aye, motion carries.
And item C, Judge, is a request on behalf of the Red Cross South Texas chapter to have requested the Commissioner's Court terminate the grant agreement that they currently have with us using the emergency shelter funding. The regulations have changed, and it makes it quite difficult for the Red Cross to abide by the regulations, since their main duty is to assist anyone in need. And of course, with the federal dollars, we have to ensure that they benefit low-income individuals.
Is that directly from y'all's portion?
I'm sorry?
Is that directly, those 84,000 coming directly from y'all?
It's coming directly from the Emergency Shelter Grant Program.
Okay, move for approval.
Second.
Those in favor indicate by saying aye. Aye, motion carries.
Thank you, Judge, Commissioners.
Thank you, ma'am. Next item, item 15, our Elections Office.
Good morning. My name is Melanie. I'm here on behalf of Ms. Ramon with the Elections Department. Item 15A is requesting approval of the following claim invoice with authority for the county treasurer's to issue payment and check after review, audit, and processing procedures are completed by the county auditor. There's two different invoices, one that was dated on 10/4 in the amount of $258.02, and one on 11/4/2012 in the amount of $48.03.
Move for approval.
Second. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you.
I was hoping that Ms. Ramon would have been here to explain what happened in Hidalgo, in the city, in that school board election.
I know she had a meeting this morning, that's why she wasn't able to be here, but I'll get back with her on that, that way she can go ahead and
Put it
inform.
on the agenda as an agenda item for next week.
I will, thank you.
Does she have any information?
Do you, sorry, ma'am? The question was, do you have any knowledge of it? Of what happened in Hidalgo?
No, I don't have any knowledge of this time.
Thank you.
Good morning.
Good morning, Teresa.
We have item 16, request approval of application and certificate for payment number 1 in the amount of $52,713 submitted by Del Sol Homes LLC, awarded contractor pursuant to action taken by Commissioners Court on 10/23/12 for proposed building relocation of Palmview One Center and as certified by project architect Denenbaum Engineering Company and McAllen LLC.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The next item is discussion and approval appointment of one community representative by each member of the Commissioners Court to serve on the Hidalgo County Head Start Policy Council for 1 year according to 45 CFR Chapter 13, 1304.50B1-B7, beginning October 2012. And this is the position that pertains to Judge Garcia appointment.
Right, well, as you know, my appointee has been Mr. Vela, Jesse Vela,
Yes.
who was recently elected to a position on the PSJA school board. And I know we've looked at the issue of whether he can do both functions, serve in both capacities. But I'm visiting with him to see whether or not that is going to be the case.
Okay, so
From his
at
own
this
level.
time,
So-
we'll bring it back next week?
Yes, put it on for next week.
Okay, we will. So therefore, that action has no, that item has no action. The next one is discussion and approval for Hidalgo County Head Start Program to exercise the option to extend for an additional 1 year or 2 year terms the interlocal agreements for Head Start facilities under the same terms and conditions with the following entities. Number 1, McAllen ISD, Austin One Stop Head Start Center for 2 years. Number 2, McAllen Housing Authority, McAllen 5 Head Start Center, 1 year. Number 3, McAllen Housing Authority, Vine Terrace Head Start Center, 1 year. And number 4, the City of Weslaco, Weslaco 1 Head Start Center, 1 year.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
The next item, D, discussion approval for Hidalgo County Head Start Program to exercise option to extend for an additional 1 year term the lease agreements for land under the same terms and conditions with the following private entities. Number 1, San Martin de Porras Catholic Church land at Western Road Head Start Center. And number 2, Daniel Garza land at Granjeno Head Start Center.
Move for approval.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Letter E is discussion approval on request to purchase 3 cargo vans through the Hidalgo County's membership participation with the Texas Association of School Board, TASB, by board's awarded vendor Caldwell Chevrolet, including TASB administrative fees.
So moved.
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
And finally, it's letter F, a request approval of application and certificate for payment number 2 in the amount of $30,576.44 submitted by Del Sol Homes LLC, awarded contractor pursuant to action taken by Commissioners Court on October the 23rd, 12, for proposed building relocation of Palmview One Center as certified by project architect Denenbaum Engineering Company, McAllen LLC.
Move for approval. Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you very much.
Thank you, Ms. Flores. Item 17, Mr. Villarreal, Precinct 3.
Good morning, Judge, Commissioners. Item A, requesting
sir.
approval of accepting participation from 5L Development LTD in the amount of $23,203.50 for road improvements of Mile 1 South Road.
Check.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you all and have a happy Thanksgiving.
Thank you, sir. Item 18, our Budget Office.
Morning, Judge, Commissioner. Sergio Cruz, Department of Budget Management. Item 18A is approval to process payment of claims for 5 invoices as listed on the agenda for vendor Valley Metro Security, with authority for the county treasurer to issue payment after review and auditing procedures are completed.
Move for approval. Second.
Judge.
Those in favor? Yes.
I don't believe I'm going to be able to issue payment for these invoices. The county has exceeded the $50,000 purchase for these kind of services.
Marty.
And it requires a competitive bidding process, and it was not done. I think that the county had a contract, but it expired
That's
prior
correct.
to the provision of these services.
I think Marty's got a little more information on that as well. Marty? It's on the Valley Metro.
I apologize. On this situation, what we have been able, the information we've been able to gather is that Valley Metro was contacted by several user departments due to concerns on the safety of the residents, plus to preserve and protect the property of the county. Now, there was a miscommunication of some sort that the program has always been handled by a point of contact. Valley Metro's contract had expired when these directives were given by either bailiffs of sitting judges or different departments that called. However, Valley Metro conducted the services at the behest of elected officials or employees of elected officials and provided these services. Now, when we discovered this, it came apparent to us that Valley Metro's current contract had expired. When we did interview Valley Metro, and they've even sent an email to that effect, telling us that they were directed and requested to provide these services for in one case, one district judge was to preserve and protect the property, and in more specifically for the protection of the residents that enter the court.
And if I may, that falls in line with respect to that request because of the security issues that we've had and that we're all aware of.
The problem, though, is that there was an existing other contract by another provider that apparently the user departments were more familiar with Valley Metro because they've been our provider for quite some time. So there was a lack of communication. Valley Metro was very aware, though, that their contract had expired.
Have you fixed this?
Yes, it's been fixed.
Well, what I'm telling, I discussed this briefly with the auditor's office. I understand their concern because, in essence, the county does expend more than $50,000. That's why their contract's in place. However, as I said, the miscommunication was from these user department either directors or elected officials, that's who they know as a point of contact in the past, called the company and asked them to render these services. Valley Metro is very aware. The existing second contractor has now been engaged on a system that is overseen by Constable Precinct 4. So they're the only ones that can be contacted to send requests for services. As I started to say, the auditor's office did want something from any one of the user departments at this point stating that it was a concern for the safety of the residents, plus to preserve and protect the county property. I have been told that by the vendor. I will be glad to submit such a memo summarizing that concern if that will be a solution that we can work with.
Marty, you know what the law requires, so whatever the law requirements are, had to be complied with.
Well, in our purchasing policies and procedures, there's also the provision that if we receive a a substantiated document that says that is why these services were rendered, and we accept that from the competitive bidding requirements, then it can be accepted by the court.
Steve, is this one of those matters that can be submitted as a claim?
Their concern, Mr. Crane, is that because we exceed 50 of competitive, and that was done. However, this particular contract had expired. Because the user departments are familiar with this company, not our second one, which is called Simez, I will also give you that the user departments really don't have that discretion to be requesting individual services. It's done through a point of contact on the contract. That I will tell you is the problem here. However, the services were rendered.
Judge, to answer your question, either way, we're going to be violating state law.
But do we owe them? You have to pay them.
And basically, that's just confirmation you violate state law.
As Mr. Eufrasio had, in another conversation we had yesterday, the vendor would need to follow, file suit, and it would be a district court or county court at law that would have to issue the order that they be paid.
Well, then just
I don't
go
know
ahead and
if-
tell them that then, so that they can start the process, and so let's bring it to a head. They've done the work, we accepted the work.
Yes, Judge, but if services were procured that were not in accordance with the statute, with the law, I cannot issue a check.
No, I understand.
No, he says to notify the company to begin the process of a
Okay.
suit.
All right, thank you.
So what do we do with this?
No action.
Take no action.
Okay. I will so inform them.
All right. Sergio, next item.
Item 18B is approval of the following personnel actions to decrease the salary for slot G059 from $7,972 to $3,750, a decrease of $4,222, and increase slot 0014 from $37,000 to $41,222, an increase of $4,222, a net effect of $0 to the general fund. This is due to one of the grants that has lost funding, so we're having to transfer the employee to another slot and increase that position slot so that they can do a lateral transfer.
This is not one of those where we're getting a pay raise for somebody?
No, sir. This is the same salary that the employee currently has, except they're under a grant. That grant, the funding for that grant is terminating, so they're switching them over to another vacant slot. However, that slot is budgeted at a lower salary, so we're increasing, basically reducing the general fund on one position and increasing the general fund on the other so that they could do a lateral transfer. There'll be no change in salary for that employee.
In the past, we could go on record as saying that people that get hired on a grant, they'd be notified that if the grant expires, that's the end of the job.
Yes, sir.
And now
They have a vacancy that they can transfer this employee into, and that's the reason for this action.
At a higher amount?
At the same amount that they're currently making. However, the position that's vacant would have to transfer some monies from the old position, the general fund monies, from the old position to the new position so that we can keep them at the same pay.
Well, my concern is if I don't know that the court has decided to follow this procedure. And if it's in compliance with whatever the court had decided, then fine. But let's not make any exception.
No, sir. This is mainly just a cost reallocation, basically switching them over to more general fund funding from an existing slot. We have done that in previous.
So this was something that was approved during the budget process?
No, sir. This is new. Basically, they just got word that the grant funding is terminating, so they're having to transfer that employee over.
But we have that slot available?
Yes, sir. They have an open slot available, yes. And item 2 is approval of the salary schedule.
You need action or what?
Yes, I would need action.
Move to approve.
So we can amend the salary schedule and
Move to
action on the
approve.
change.
Second. Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Item 18C is approval of 2012 appropriation of funds for the District Clerk's Record Management and Preservation Fund in the amount of $25,000. This is to fund record storage and retrieval services.
What's approved?
Second.
Those in favor indicate by saying aye.
Aye.
Aye, motion carries.
Thank you, Judge Commissioners.
Thank you, sir. Item 19, purchasing.
Yes, sir. Going on to Martha Salazar for purchasing, 19A1, 2, A, B, and C, nothing to report or action to take. Item 3. The first item is the status of attempts with applicable action if necessary to secure commitments from current awarded vendors on the following Section 125 products. I'll give you a list of the current providers. It is my understanding the only thing that I believe we can do at this point is request, as under the original RFP, that these providers stay on for an additional 60 days in the event we don't meet the deadline for implementation of the new providers. Now, currently the only two, it's critical illness, I believe, and the universal lives. Those two could be kept on a conversion basis by those employees that currently have those two policies. Of course, it would be on a bank draft basis, post-tax, and the rates would be higher, more than likely, for those people who wish to keep them. Okay? Now, I haven't been clear, I haven't gotten any responses to my emails where I am telling the representative of the Allstate plans that we do have that 60-day provision in the event we don't meet our 2/1 deadline implementation. But as far as item B on the action by Commissioners Court, if applicable, would be the conversion of those policies that current employees have for only two of the products, which is the universal life and the critical illness. I believe it's the critical illness, which has or the cancer. I know there's 2 out of the 3. The rest would cease to exist after the 60-day. They would not be renewed. We can also, I've been asked by members of the court, could we keep the current providers for a year? Or even I suggested for an 11th-month term. That also cannot happen because the only provision on the original RFP was 3 years, options by the year to renew, and the 60-day grace period extension. So the options left to the court, which I've tried to put every option available, is to accept or reject all the proposals received and thus not proceed to rank them for all the products that are named. Or if you proceed to keep them, you would rank the proposals and we would begin the process of negotiating with the number 1. You have, in 2 instances, tied grids, so you would have to draw lots. My recommendation is to reject all the bids, put out a new RFP. In connection with that, I am also asking, I'm summarizing everything that's on, then we take it one at a time, would be that, as Commissioner Flores had suggested, and I have put it on the agenda, is to name a new grading committee. In that respect, and because I know the court has spoken about...
I don't want any lawsuits. I mean, I want this to be taken care of. Couldn't we just negotiate with the number 1?
In each category?
Yes. I mean, a lot of those people actually don't qualify, and they were thrown into this, right?
Well, that's what I'm saying. So how do you proceed to rank if you have doubts?
No, but they've been ranked. I mean, they're people.
No, well, they'll have to be ranked by the court. They will have to be ranked.
All
you have right now are the grids. All you have right now are the grids with the scores. So you would proceed to rank them, and then you start negotiating with number 1. But remember, on a lot of these companies, it has come to our attention from the graders that as you said, Commissioner, if they didn't abide by the no loss, no gain provision, then your number one, if it doesn't have that, we're starting to negotiate. The first thing will be, are we going to be able to negotiate that out?
Explain this no loss, no gain provision again.
Would be that your guaranteed issuance and pre-existing conditions
All right, that's
would
the
be
one that you had
accepted.
talked about, the
Yes, sir.
pre-existing
Yes,
condition.
sir.
But
Some
several of these
companies, and that's a business decision on the part of the company.
several of these companies did not comply with that when they.
Well, let me explain. An RFP merely is a set of requests by the issuer, which is the county. So what you do is then look at what they proposed and see if they came as close as possible to giving you what you needed. Okay? After that, you negotiate.
I think we need to wait one more week. We need to really
Okay?
look at this.
There is another request that I've gotten from the court. I just want consensus because it's not on the agenda. I'm going to explore for the court the suggestion that an agent of record be named. Now, where I am not clear, and I'm going to defer to legal counsel, is that I believe, and I may be proven wrong statutorily, that an agent of record would have a conflict of interest in also being an agent representing a company. I may be proven wrong, as I say, but I'm going to defer to Mr. Crane.
Why are you making that comment?
I'm making that comment because it was suggested to me by members of the court. An agent of record would participate in the RFP process and also assist the graders in deciphering the proposals.
Is that true?
Then
Let me phrase it differently. I think what Marty's looking for is a person to, if you went back and re-ranked, or if you used that person as a consultant to help purchasing negotiate the contracts, could the person who is acting in the capacity as a consultant also be a vendor? And to me, there's a clear conflict of interest.
or an agent for a company.
It sounds clearly that there is a conflict.
It appears to me, but I say I would like to be clear.
Mr. Crane, when you appoint an agent of record, wouldn't that person's duties be to represent the county and make sure that we're getting what's best for the county? And he's already an agent of record for the county, so he'd be working for the county.
Let's use the terminology that Marty's trying to get to is really a consultant to help her office with the ranking.
Yeah, if you're looking for a consultant to help you with the ranking and try to get the
Let's not confuse labels with what the person's going to be doing.
Well, if you're looking for an individual to help you with the ranking.
Which I have as an option.
Yeah, then I could see where it would be a conflict and could not be part of the vendor process.
Yes, the one that I have on the agenda that I'm suggesting to the court, but that's merely my recommendation, I know is not involved in any of the submitted proposals, nor could he be at the approach I'm taking, which is a consultant. I don't know if the term agent of record, of which I believe there is a statute, is in effect tantamount to a consultant, and thus I perceive there may be a conflict of interest.
All right, let's.
So you want to take no action.
Isn't there a difference between an agent of record from a consultant?
Pardon me?
Is there a difference from an agent?
That's what I need to determine. That's what I need to determine. In my experience, I would say that an agent of record would certainly be in itself tantamount to a consultant. But I may be proven wrong by the statute. I don't want to give the court misinformation.
And my comment to that is what you're looking for is a consultant.
To assist the grading committee, not to...
We don't need to worry about the terminology. We've got to look at what that person would be doing.
Correct.
And when those services be in conflict with also being a vendor. And I think they definitely would be.
I'll put it on for next Tuesday.
My recommendation is to wait another week.
And now, this is a short week, so would you like it the week after to have enough time to, and I'll have enough time to research and report. Now, this may then trigger on the next time we consider this to change the plan year.
Well, you did it for you renewed it a while ago for how long?
60 days?
Well, the 60 days is in the RFP. I'm expecting these companies to abide by their contracts. Now, I am still going to issue another email to them advising them of the same, but in order to meet and have enough time, whichever course the court takes, including the issue of a consultant or agent of record.
Let's not use that term.
Okay, I apologize.
Flores.
to assist the committee in the grading process. As the court had alluded before, they'd like some expertise on the committee, on those graders.
Marty,
And
you
I think that
obviously
is
have
good.
focused in on an individual. That's why we're even getting involved in the discussion. Have you asked him or her whether or not they intend to be an agent and a consultant at the same time?
I have been approached by a current agent representing one of the proposals.
Judge, if I can answer that question, the person that Marty has talked to does not, who she's considering, is not involved in any way as a vendor in this process.
Well, she's proposing a William Rusterberg.
Yeah, he's
Yes.
done work for the county before.
Right.
He's been a consultant to the county before.
My question really relates to if we have a person right now that you're focusing on, that the reason we're involved in a discussion, that submitted a proposal and wants to be an agent, and that person may want to not be an agent and just be a consultant. I mean, have you looked at that?
The court, a couple of members of the court had proposed the agent of record, and I'm sorry to keep repeating, but that's the way it was asked of me. My first response to the members of the court who proposed this was that I felt there was a conflict of interest doing it that way. Let me give you an example. Mr. Looney, at this point, is our consultant on group health, but he does not participate in any, does not represent any company when it comes to putting out our group health insurance.
Marty, you made a comment that you were approached by some members of the court.
Not approached.
For the record, hang on.
They asked.
Hang on.
They asked.
I did not approach you.
No, sir.
I called her.
That's all I'm saying.
I called her and I told her to look at it because there was the short term, the long term was not included on there. I looked at it and I saw it was wrong the day it was going to be approved, right?
Yes, you asked,
Yeah.
she asked me.
I looked at it.
And I had a conversation with Judge Garcia about it too.
Record, I want to make it clear.
My first response to them was that I felt it was a conflict.
Okay, one at a time.
And only because I was using as the model that we currently have for our group health benefits consultant as being precluded from participating in the process. So I likened it to the same thing.
Yes.
But since the issue has been brought up again, what I'd like to do is be correct in the information I'm giving you, and does an agent of record have the ability to do both?
Can you explain to the court what would have happened if we would have accepted it back then?
Accepted what?
Whatever we're working on right now, the cafeteria plan.
If when you first brought it to the attention of the court.
If we would have approved it back then, what would have happened?
You would have ranked them, accepted the scores.
But what would have happened to some of the employees?
Oh, at the time,
That's
they're
what
going to
I'm
lose, they're going to lose the current coverages that they have. Yes, and we
It
don't.
would be totally unfair to the employees because they would lose out on pre-existing coverage for pre-existing illness.
Well, and they're going to lose anyway in this respect, that only 2 or 3 out of the 7 products we have can be kept on a conversion basis. The rest will not agree to accept a conversion to a post-tax bank draft individual basis.
So the only way it would work
is that if we get responses from either the ones that are already graded or put out a new RFP that gives us as close as to what these employees have now as possible.
But you being at the purchasing, why did we even include those ones that didn't have the long term? Or who was?
Well, there's a couple that don't have long term. There's a couple that
several.
don't have cancer.
Yeah.
Correct.
I mean, was the insurance department?
I go back to the fact that these are the scores that these committee members produced.
But the question is very different, Marty. Commissioner Flores wants to know if the RFP requested that long-term coverage and they're not providing it, why are we even considering
Well,
it?
not all of them are not providing it.
A lot of them were.
Some of them aren't.
I mean, they should not even been included on the ranking.
Well, I agree with you,
that's going to be my
Commissioner,
point.
but those are what the scores reflected, that the graders may not have been aware that the long-term
We've got
was not.
1 week to clear it up.
I had not one question from any of the members of the committee to define certain aspects of the RFP.
Well, and the problem with that is because they were given a task that they weren't specialists in, and we didn't go back to the original committee style.
And I agree with you, and that's why
My
I'm
staff-
proposing that I believe any new committee that is assigned, if we go to a new RFP, be given some assistance by a consultant. I would think it's important.
I would like that committee to be expanded, just a representative from each member of the court.
As we did before.
Yeah, well, as we should do.
Why can we form a new committee, Steve, and go back and regrade again?
I think you're opening yourself up for potential lawsuits.
Marty,
But shouldn't those
did
individuals
we-
be disqualified if they didn't, they're not providing what we required?
Pardon me?
Should those proposers be disqualified if they're providing something that?
That's
But
what I'm
they've
They're not
been-
providing something that we require?
But the court has at this point been presented a grid. Has been presented a grid by a committee they appointed.
No, but what I'm saying is that any proposer that did not meet the criteria that we
Should be
set up as
automatically
spec
be
should have been
voided.
disqualified.
Should have been, I agree with you. At this point, they have not been.
No, but they
Nor
should
was
be
I
done.
asked was I asked by any of the committee members, does this meet disqualification? I was never posed any questions by the committee. At this point, Mr. Eufrasio, if you go back and disqualify him, I think Mr. Crane is right. You do have the basis for the very minimum of protests on the grades. They're going to say, well, so now you are either not accepting the grades, reject them, and if you're going to reject them, I don't believe naming a new committee adds to the problem. I think an RFP, a new one, is what's called for.
Let's go ahead and wait another week.
Well, no, it'll be after the holiday. Is that correct?
Commissioner Palacios, yes.
Just to make a point, last week, the court expressed a concern about some of the employees would lose out on benefit because of the new
plan.
Since last week, and that's the reason we didn't take any action on it.
Right.
So the issue remains the same. We don't want somebody losing benefit that's in dire need of coverage.
And that's my argument for a new RFP, because I believe a new RFP will modify the requirements to state specifically to the vendors out there. The court sends a message, sharpen your pencils, increase benefits. You know what the court is looking for. Now, business decisions may still have to be made by these companies, but we're saying we want as close as possible that our employees, if it isn't the existing companies, then whoever takes this new award comes as close to their benefit.
Marty, I think that it's a consensus of the court as well as yourself that we're all looking for the best product
Exactly.
for the employee. I think we got a week to clear it all out, to figure out what is
It'll
the
be
best.
2 weeks from
Or
today.
2 weeks to clear all that out and to assure we do the right thing. I think the whole court is in consensus with that.
I can inform the court today, though, that of the 7 products, only 2 to 3 of them can be converted, but it won't be at the same rates. The other companies will not agree to conversion or grandfathering.
I just have a question.
So that's why I think it's tantamount, it's important that we go out on a new one so these companies get the message.
The question I have for you, ma'am, is, and with all respect to you, because I know you're doing your best, but who do we have that's a qualified person that understands the terminology and understands exactly what this court wants to try to get there and find solution?
Commissioner Flores had suggested from his office, Mona, myself, and Mr. Raul Silguero from Precinct 2, who he believed had the most familiarity with the scoring and grading concept. However, even at that point, I believe expertise to the grading, assistance to the grading committee would justify grades that are issued, because we would have answers from a consultant. I'm not proposing that the consultant grade and score. I'm proposing that any questions we have on interpreting terminology or clauses on the proposals, we be given the advantage of having someone in the field.
So you don't have anybody, is what you're telling me? You don't have
Not
any-
with every, not with all the
Understands it,
intricacies,
understands it.
in my opinion, of what these companies can offer.
He's just telling us we can't form a new committee, we can't regrade.
I believe Mr. Crane is of the opinion, and so am I, that we're going to have protests on that issue.
Yeah, because you can't change what's already been done. I mean, it's already been graded.
And the grades have been published.
Just throw out the ones that didn't meet the criteria.
So that's why you want to do it again?
I think we need, well, I think we need a new RFP, and we also we send a message on what benefits we are exactly looking for, which are in the best interest of our employees.
Who is the county's, I know they don't want to use the terminology agent of record, but.
We don't have an agent of record. The county's never had
Do
one.
you have any idea how many employees would be affected if we were to proceed?
Right now, I found, I do have a figure of how many employees have Section 125 products. 2,200 out of the 3,000. Now, I can tell you exactly how many have those products that I believe are at most risk, which is the disability, not disability, I'm sorry, which is the cancer, the long-term, and which was the other one that I mentioned, and universal life. I mean, not universal life. It's everything other than those that can be grandfathered.
How many?
I don't have that grid, but I know in totality, 2,200 plus policies are issued.
Right.
I mean, 2,200 employees buy products.
So we should have done this at the beginning, basically. Finding someone or somehow have someone in place that understands all the terminology.
And, you know, just to give, it may not have been the entire makeup of the court that exists now, but I will tell you in the past, the court did provide consulting to the county as far as our Section 125 before. I think, as I said 2 weeks ago, we became comfortable in the fact that we had an excellent Section 125 providers right now through Allstate, Unum, and MetLife. However, what happened was that since we enjoyed the 3 consecutive years, we fell into a false sense of security as to we were going to be given the same type of offers again, and that was not the case.
Well, we got, I guess, 1 or 2 weeks. 2 weeks is what you're
For
suggesting.
the court to finalize what the options the court might want to take. And I will be able to inform you in a much more certain basis on that assistance to the court by an expert.
Then no action for.
Okay, let me move on. Under the executive office, we have the presentation for discussion, acceptance, and approval of the conceptual layout for the new Commissioners Court room facility as developed through the project architect, Alcocer Garcia and Associates, from directions proposed by executive officer for Commissioners Court. You do have a layout as part of your backup. This was meticulously reviewed by Mr. Guerra and felt that those changes or that final layout is what represents what the court needs in this facility.
Have you seen it, Joe?
It is part of your layout. It's the only attachment to that item.
The concern that I had is really actually the one that was voiced by that individual in open forum is, do we have a need for 4 offices for the commissioners?
I believe that one of the issues that and I won't speak for Mr. Guerra, but I don't, in discussions I had with him, were that those 4 offices will be multi-purpose in the event we have an EOC, in the event you have private discussions that have to go along in a civil service meeting. Those can be used for privacy purposes, and in the event of an EOC, it would be departments that need it, and the size of the building in an EOC wouldn't need to be as ample as possible.
Actually, they're not county commissioner offices. Right.
And Marty,
Well,
this is
they're
the first-
marked that way, but
Well,
they can be multifunction.
It's never been presented to me that it was going to be a precinct office. I think they're just privacy offices in the fact that you pull not private discussions, but discussions that need to be
In
held
general.
in quiet room.
Correct,
They have access
correct.
for that.
And what I was thinking, suggesting was, I mean, at some point, we may want to get one of those TV licenses, and we may need that area to develop whatever it is
Well,
we're going to be
there's a media
broadcasting.
area for you also. But you may have more employees, and they can be taken up by those areas also. In the effect, you get the FCC license. I'm sorry.
One of the main concerns, Commissioner
Can you
Judge,
get near that mic?
one of the main concerns is if you have a sidebar meeting that you need to meet with your staff, that we have a room other than the main room in the back, so there's no question of the Meetings Act, so that you can meet with your staff individually on any type of sidebar, rather than going in the back and then having 3 commissioners in the back or so on. This way you can take care of that business and then get back to the bench.
Well, all we need for that is one, because they're not, I mean, all the commissioners are not going to be in meetings at the same time.
But that was the purpose of placing those
For
offices
that,
there.
you never see me go out there and meet with Mingo or Mona in the back.
Yeah.
Very seldom, maybe once in 16 years, 15 years.
But that was why it was put in there.
What about just one large conference room where,
You have an executive room.
Yeah.
good.
You may want to direct Mr., then you won't, then I guess there'd be no action on either one, because we'd have to present this again. If you want any modifications, and give direction to Mr. Guerra to speak to the architect. What's the wish of the court? Unless you want to approve it and we delete the 4 rooms, the 4 spaces.
Take care of it.
Go ahead.
Do we need any action?
So do you want to proceed with the modification to delete the 4 offices?
But those doors couldn't be on the other side where a small department could fit in there instead of having it for the commissioners?
Just create one small area?
Just one area, that's all we
Okay.
need.
Okay, so
Conference.
you want to approve subject to that change? Okay.
Move for approval?
Second.
There's a motion and a second. All those in favor say aye.
Aye.
Opposed, motion carries.
And then B is to authorize the project architect to proceed with the design development phase for the addition for the Commissioners Court with those modifications that have been approved, that have been suggested.
Second.
Motion and a second. All those in favor say aye. Aye. Opposed, motion carries. Next item.
Item C1 for Colonia Access Program Precinct 2, acceptance and approval of the following for CAP Contract 206, Rancho Escondido subdivision between Hidalgo County and Asago. That is a final construction contract in the amount of $363,487 as approved by Commissioners, as awarded by Commissioners Court on October 23rd.
That's approved.
Second.
Motion and a second. All those in favor say aye.
Aye.
Opposed, motion carries.
And pursuant to Texas Local Government Code 262-031, and in the interest of expediting a project's progress, requesting authority and approval for a precinct commissioner or designee to execute change orders that involve an increase or decrease in the cost of $50,000 or less.
Move for approval. Second.
There's a motion and a second. All those in favor say aye.
Aye.
Opposed, motion carries.
Item D is authorization to purchase through Hidalgo County's membership and participation with the TASB Buy Board's awarded vendor Philpott Motors, the one Ford Expedition Special Service Model in the amount of $26,339, which includes the buy board fees and delivery.
That's approved.
Move for approval.
There's a motion and a second. All those in favor say aye.
Aye.
Opposed, motion carries.
Thank you, that's all I have.
You'll need a motion going to executive session.
Second.
Motion and a second. All those in favor say aye.
Aye.
Opposed, motion carries.
All right, we're back in open session. Mr. Guerra?
Thank you, Judge. Commissioners, Item 21A, no action. Real estate. Item 21B, pending potential litigation, no action. Item 21C, under economic development, no action. Item 21D, claim of Angelica Hernandez, Judge Commissioners. I'd like settlement authority to make an offer in the amount of $8,489.14.
Those in favor indicate by saying aye. Aye. Motion carries.
Item 21E, Judge Commissioners, claim of Ernesto Hernandez. Once again, I'd like settlement authority to make an offer in the amount of $14,184.81.
Those in favor indicate by saying aye. Aye. Motion carries.
Thank you, Judge Commissioners. I have no further.
Need a motion to adjourn? Those in favor indicate by saying aye. Aye. Thank you very much.